Hi, everyone. Welcome to HYLA's March CLE offering. Today, we will be hearing from a really incredible panel about abortion bans, pregnancy prosecutions, and reproductive rights. But before I formally introduce our panelists and we kick things off, I want to offer a couple of housekeeping items or cover a couple of housekeeping items. Our illustrious panelists will be answering the questions that you all pose in the Q&A at the end. So just please put your questions in that Q&A tab throughout the presentation as they come to you, and they will reach those at the end. Please remember to self-report your CLE credit on the State Bar of Texas website. I'll be adding the course number for that about halfway through the program. Please remember it is your responsibility to report the amount of CLE that corresponds with the amount of the program that you watched. We will be putting the panel portion of this CLE up on our YouTube channel. We won't be recording the Q&A portion at the end, so that will not be put on YouTube. And while, people are welcome to watch that, you can only get CLE credit for watching it live today. Thanks for bearing with me for the boring stuff. Now it's time to get on with why we're all here. We're delighted to be joined by Blake Rocap and Cristina Ramirez from the Sissy Farenthold Reproductive Justice Defense Project that is housed at the UT School of Law, and Liz Jarit of the American Civil Liberties Union. And they will be discussing reproductive rights and all that jazz. So I'm going to be posing the questions throughout this, but I'm not an expert on any of this stuff, so I'm going to leave it to them. Starting with one of my first questions is, what are the current legal exceptions to Texas's abortion ban, and how have they been applied in practice?
Thanks, Katie. I'll try to answer that. So Texas has a single exception to the abortion ban, which is for, in the statute, it says it's for medical emergency. The substance of that exception is really for the life and health of the pregnant patient. It's kind of a multi-part exception that requires two or three different things to be true before the physician can provide the care that the patient needs. And it was, litigated. What the exception means was litigated in the last 2 years, and particularly we got some more information about what it means last summer in the Zarowski case. But so the substance of it is that a pregnant person has to have a life-threatening physical condition that poses, a risk to their life or a serious risk of injury to a major bodily function. And so the court has really said that, this risk doesn't have to be a huge risk to life, that any risk to life makes an abortion legal, because if not, the abortion ban would not be constitutional under the Texas Constitution, which protects life. So the life exception is extremely broad. Any risk to life counts. And then any condition that poses a small risk to life and also poses the possibility of major injury to, sorry, significant damage to a major bodily function. In those circumstances, then physicians are allowed to provide abortion care. It's a little confusing. We've gotten more clarity on it because of the courts, but the big issue is the severe penalties that come along with getting it wrong and not practicing medicine within that exception, however clear or confusing it may be. The other thing that I'm learning every day is working with doctors across the state who are trying to care for their patients within the law and understand this exception, is that their diagnoses are not nearly as black and white as what the law is. So we know there's some also not just this medical emergency exception, but exclusions from the definition of abortion, including ectopic pregnancy, and instances where there's already been pregnancy loss. Those are not always diagnostically 100% determinable, and doctors are left facing the decision, I think my patient probably has an ectopic pregnancy, But if I'm wrong, I go to jail for 99 years. So they're really delaying care until they're more secure in their diagnosis, and that can sometimes be really harmful.
Have we seen an increase in prosecutions of pregnant individuals in Texas under this framework or
So
other frameworks?
I can take this one. So generally, I would say, and I think everybody here on this panel would say that pregnancy prosecution and criminalization of pregnancy and pregnancy outcomes has been going on forever. I mean, there's organizations that have been doing this work in these spaces for a lot longer than the Dobbs decision and before the Dobbs decision. So is there an increase in prosecution? So I think, again, there's pregnancy criminalization that's not just, related to the abortion bans. And I think one of the things that we've discussed earlier as a panel are people being prosecuted, pregnant people being prosecuted in Texas under child endangerment or similar type of laws. So I don't know if we would say it's an increase. I think it's a continuation of, and I think that there are some things that have happened post-Dobbs that we see maybe affects who is arrested for certain things. I can speak specifically to Texas, and Liz might have some more to offer on a more national level. But at our project here at UT, we partner with Pregnancy Justice and some other law schools to do a pregnancy prosecution tracking study. And we were fortunate to be able to have lots of resources to throw towards this study. And in 1 year post-Dobbs, they documented at least 210 prosecutions related to pregnancy. And that was the highest number that they had ever documented in a single year. But again, realizing that we had a lot more resources and efforts to put towards tracking these cases. So I don't think it's necessarily apples to oranges, but also since we reported that data out and the interim report came out in September, we have found even more than 210 cases that will be reported on in future years. So while I don't think we can compare the 1 year post-Dobbs to the 20, 30, 40 plus years before that to say it's an exact increase, it's not an exact science. I think we are seeing, like as recently as last week, I'm sure a lot of people here heard about the Waller County case, which I think we might discuss later on during this panel if it should come up. But there are, that was the first prosecution that we've heard of in Texas where they're prosecuting a midwife for providing care. But and just to go back a little bit more to talk about other types of pregnancy prosecutions, we know that people are being prosecuted for behavior during pregnancy under child endangerment statutes, such as injury to a child, endangering a child. In Texas, I know we've also seen other types of cases like abuse of corpse or cold cases that we've heard about in the last several years, where there was fetal remains from over 20 years ago, and they're now using different kind of genealogy and genetic testing to try to identify a parent that was related to the fetal remains. And we know several women who have been prosecuted under capital murder and manslaughter charges. So I think that there's also seems to be a push, and that might be because of science, right? Like science that wasn't available 20 years ago. But it also can just be, I think, and I think some of us in the spaces think, as maybe an unintended, maybe an intended consequence of Dobbs. There's heightened surveillance of certain populations, which again, we'll kind of talk about that a little bit more later. So if we can say there's an increase, well, we can say that last week some people were prosecuted for providing allegations of providing care to someone regarding abortion, but we've also just kind of seen a continuation of pregnancy prosecutions that have been going on for a long time.
Yeah, and I'll just add, very briefly. So my organization at the ACLU, I'm part of an initiative called the Abortion Criminal Defense Initiative, and we get intakes across the country for folks who need criminal defense representation related to either a criminal investigation or prosecution that has to deal with abortion care. And I'll just add that, since the last election, we've also seen local authorities, local law enforcement, local prosecutors just feel more emboldened and have seen like just an increase in intake since then as well.
Thank y'all. So can Texas realistically prosecute people who leave the state for an abortion, and how does Dobbs impact travel restrictions?
Yeah, so I can take that one. So first of all, I think it's really, really important to remember that at least when we're talking about the ban itself, the abortion ban and the criminal abortion ban in Texas, that the pregnant person is exempt from prosecution under that statute. And so, you know, that's just underlies all of this. And there are other ways that the state can try to criminalize that pregnant person's conduct, but at least under the ban itself, that pregnant person should not be criminalized. That said, we've seen, we've seen prosecutors wrongfully accuse folks of crimes that they should not be accused of, even when there is exemptions. And the second thing to remember also is that it's generally not a crime to leave your state and go to another state and engage in activity or conduct in that other state that is entirely legal and that occurs in that other state. So, this rule is based on constitutional principles of state sovereignty and federalism and due process and right to travel and privileges and immunities. And, as an example, in some states, it's a crime to gamble, right? And lots of people travel to Vegas every year and go gambling publicly, openly. And those folks are not being prosecuted in their home state where it might be illegal for them to gamble if that conduct occurred in the home state. And so I think it's really important to remember that the right to travel is still a protected right. It's a fundamental right in this country. For folks who are traveling for care, and if that care occurs wholly out of state, that it should be protected. That's not to say that prosecutions might not try to happen, but it should be protected conduct. The other thing to remember is that, every state articulates rules about the extraterritoriality of their criminal statutes. So in Texas in particular, it's a statutory rule. It's in the penal code. And that code states that Texas has jurisdiction over an offense if, quote, either the conduct or result that is an element of the offense occurs inside this state. And so it's important to look at the applicable crime that might apply in a situation and determine, like, did an element occur in Texas? Did a result that is an element occur in Texas? In order to try and figure out if Texas even has jurisdiction over that conduct. In terms of Dobbs, the Dobbs itself did not impact a person's ability to travel. And the concurrence even supports an argument that right to travel for abortion care is protected as well.
Yeah, and just to, sorry, Liz, are you done?
I'm done.
Just to jump into, I think it's just a point. It's important to make a point that living in Texas, where we, have a wide population and a diverse group of people living here, I think it's always important to bring up and remind people how bans can affect people who are either under state control, meaning they are incarcerated in Texas jails or prisons, people that are on probation and parole and who cannot leave the state of Texas without permission from a probation or parole officer, from the courts. Those folks, or folks that don't have, that may be undocumented or non-citizens, they may face extra barriers in trying to leave the state for legal care in another state. Because they might not be allowed by their probation or parole officer. A judge might not allow them to leave. Somebody who's incarcerated, of course, they don't have the option to just leave to go seek care outside of the state. And similar with non-citizens, and we're seeing a lot right now happen on the federal level that a lot of people are questioning what's going on. But even before this, just here in the state of Texas, if anybody who has traveled in Texas, that we have checkpoints in Texas that are in various places across the state where folks that are non-citizens risk coming into contact with Border Patrol or other types of law enforcement agencies if they were to leave the state. So these are some of the extra considerations I think that folks that are not under kind of some kind of state control or supervision, or who are citizens might not think about, but those are just additional considerations when we think about our abortion bans.
That's super interesting. So in terms of local versus statewide enforcement, what role do local prosecutors play in enforcing abortion bans in Texas, and have any refused to prosecute?
This is a really good question. I think another thing we try to do at our project is try to keep up with the different statements that usually public statements, but also just information we know about different counties across Texas. As y'all all know, Texas is huge, 254 counties. So it's hard to track everything, but I mean, local prosecutors have discretion, right? And I think many of us on this call, on this panel and on this call probably have heard the times when certain, what we would say, like, what people say, progressive DAs, or in the bigger cities like Austin, Travis County, Dallas County, prosecutors who came out post-op saying we will not be prosecuting these type of charges. But then, I know we've also heard of and tracked other counties where prosecutors have said the opposite, like we are, we will prosecute if we see this or if we come across this. And then I think that there are also some situations, kind of like a side note here, where even some prosecutors might not fully understand the law. A good case study in that is what happened in Starr County. It was several months before the Dobbs decision came out, but in Starr County in April of 2022, the local DA's office prosecuted a woman when there were allegations that she had self-managed her own abortion and then gone to a healthcare setting to seek care. And she was incarcerated for 3 days on a $500,000 bond before the local DA came out and in a press release kind of thing, said, we are going to be dismissing these charges because apparently this is not legal to charge her with this. There's an exception to prosecuting a pregnant person for self-managing their own abortion. So in that situation, like, the local DA's office did not, from what they say, they did not know that that was the law. But of course, that person's life is already forever changed, right? And there's litigation concerning that right now that the ACLU is a part of. So Liz might have more to say on this, but that prosecutor was actually sanctioned by the state bar earlier in January of 2024, I believe. Now I'm thinking about my years here. And now there's a civil lawsuit as well. Liz, I don't know if you want to talk about that at all.
Yeah, I can't talk in depth about it, but we are involved. We are co-counsel on the case where we are, Miss Gonzalez brought in 1983 action against the DA, the ADA, the sheriff, and the county, alleging false arrest and malicious prosecution. So that case is ongoing. And that's public, obviously.
And then that was kind of the Texas focus portion of the panel, but we're kind of going to move on to the national questions now. So generally state versus federal law. How does federal law, such as the Emergency Medical Treatment and Labor Act, interact with state abortion bans?
It's a good question, because we often, all as lawyers, have this concept of federal supremacy in the back of our minds. And for, 35, 45 years or so since MCLE went into effect, that was the rule, that this federal law superseded state law. That's really been brought into question by states who have passed abortion bans with very narrow medical emergency exceptions. And those medical emergency exceptions are not coextensive with what MCLE requires and are sometimes in conflict. There's a case where challenging the Idaho exception and asking that hospitals and physicians in Idaho be able to provide care based on MCLE and not the Idaho restriction. And that case went up to the Supreme Court. Last term, the Supreme Court decided, whoops, we decided to review this before it was ready, and sent it back down to the Ninth Circuit, and then Texas, the state of Texas itself, challenged the EMTALA guidance to say, our EMTALA federal government, you can't tell us how to run our state and our abortion ban. So what do we do? And in fact, what we want you to do is say that our abortion ban takes precedence over EMTALA. And in the Texas versus Becerra case, the Fifth Circuit mostly agreed and said, you know, the laws, although they're not identical, can be read in harmony, that the Texas law has this exception for medical emergency. EMTALA says you need to stabilize the patient. We think the patient means both the pregnant person carrying the pregnancy and any fetal life that exists. And so we think physicians need to reconcile both laws and respect them both, and that EMTALA does not at all take precedence. So there's quite a big question of federal supremacy buried in this conflict between the state abortion laws and federal law. This has also appeared in some Medicaid program regulations related to the confidentiality of contraceptive care. The Title X program allows confidential contraceptive care even for minors. Texas state law says physicians can't provide prescription contraception to minors without parental consent. Obviously, if you have parental consent, then you don't have confidential care anymore. So those laws are in conflict. And the Fifth Circuit has also said, actually, we can reconcile those laws so that the physicians in Texas have to follow Texas law, and confidential care really doesn't mean what everyone has agreed it's meant since Title X went into effect. So those are kind of two examples where this politicization of abortion and reproductive health care has really allowed people to make arguments about the relationship between federal and state law that are not necessarily what the jurisprudence on that area in the last 40 years have been.
That's so interesting, the way that it seems that states are trying to interpret EMTALA in a different way than they, had been for however many years it was in effect.
Yeah.
So as far as the criminalization of miscarriage and pregnancy outcomes, what trends have y'all seen in criminal prosecutions for pregnancy outcomes in states with strict abortion bans?
Yeah, so this is another great question. So as Cristina mentioned before, people have been criminalized for pregnancy outcomes before Dobbs, when Roe was still good law, and that trend does continue today. And I think the numbers show an increase in those rates of pregnancy outcome prosecutions. And Pregnancy Justice is I want to shout them out here. They do a lot of work in this area and have some amazing data on this. And I really recommend the reports that they continue to put out to track these cases. And even in non-abortion ban states, we've seen pregnant people charged with murder for pregnancy outcomes. We've seen that recently in both California and Maryland, for example. And, in those cases, prosecutors have alleged that just because a pregnant person didn't grieve a certain way over the loss of their fetus, or didn't obtain a certain level of prenatal care that the prosecutor or the police officer thought they should have obtained, this means that they had homicidal intent to kill a live baby. They've alleged, for example, that waiting 10 minutes to call 911 following a miscarriage, even when that person is like in and out of conscience, is evidence of like neglect or criminal intent. We were recently amicus in a Maryland case where, in that case, the pregnant person had given birth in her home. She was alone. She was the only person to witness the birth, and she maintained that it was a stillbirth. Her every statement she gave was a stillbirth, and they charged her with murder. And the evidence that they had basically was that during her pregnancy, she had Googled, in her first trimester, she had Googled her options for termination, about how to terminate, whether she should terminate. And this is in a state in Maryland where people have had a statutory right, now a constitutional right, to make these decisions and to obtain an abortion if they so wanted to. But the state admitted these Google searches at her trial, and said that they demonstrated that she had a criminal intent, that she would kill a baby if it was born alive. And she was convicted. And an appellate court affirmed the conviction. And just in February, the Maryland Supreme Court reversed her conviction, ruling that her consideration of abortion care was irrelevant as a matter of law to homicidal intent in that case. So we're seeing this, we're seeing this all over. And we've also seen, as Cristina mentioned earlier, a growing trend to charge folks with how they handle fetal remains, whether that's a miscarriage or an abortion or a stillbirth, however that pregnancy outcome happens. And it's different in every state. Sometimes it's failure to report a dead body, or desecration of a corpse, or mishandling of fetal remains, depending on what statutes could be applicable. But we're seeing that more and more. I'm sure some of you have seen the Ohio case, the Brittany Watts case, where she had a miscarriage and they tried to charge her with a desecration of a corpse, and the grand jury decided not to return an indictment in that case. So those are just some trends that we're seeing, and I would say that they more frequently happen in abortion ban states. However, we're seeing them across the country, even the bluest states.
And I'll just add a little bit to that. We have seen these cases in Texas, and in Texas, they can charge folks with abuse of corpse. And as Liz mentioned, and I'll just highlight it, a lot of times these are situations where people have given birth or experienced a pregnancy loss outside of a healthcare setting. And so that's something that we have seen here in Texas as well, and even just in the 1 year post-obs. I think it's also important to mention, and maybe not to get into the science too much, but we also see like faulty junk science being used in some of these cases. The case that Liz was referencing in Maryland, I believe it also dealt with this, but the lung float test. And we are part of a working group that's kind of trying to figure out how and why this is being used in courts. But we do know that in Texas, there is mention of this test. So there's lots of, I should have gotten a link so that we could send it out to folks to read a little bit more about it. But the lung float test is basically a test that law enforcement, or the state prosecutors in court, law enforcement, when they're investigating, try to use to prove that there was a live birth versus like somebody reporting that they had a miscarriage or experienced a stillbirth. And basically they say that based on the autopsy, that they can prove that there was some type of oxygen present in the lungs, which means that this baby, this fetus, must have taken a breath, which means it must have been born alive. There's lots of issues with this test, and again, like we would call it faulty junk science, the way that as a criminal defense attorney, you know that there are things that are no longer allowed as evidence in a courtroom because at one point they might have been seen as okay science or good evidence, and now they've been disproven. And so it's very similar with this lung float test. But we're always interested to hear if people find cases where this is still being used. I know that there was mention in at least one of the cases, those cold cases I was talking about earlier, that the state was potentially trying to use this lung float test to prove that that the fetal remains that they found over 20 years ago, that there was some type of oxygen present in the lung sac. And it's problematic, but it also, as Blake points out, a lot of times when we speak to people and give presentations, it can really determine whether or not they can charge somebody under the homicide statute, or whether they charge somebody with something similar to what Liz is talking about, which is like improper disposal of fetal remains, or in another type of charge here in Texas, abuse of a corpse. So it's obviously those type of charges carry widely different penalties. But we are trying our best to get our word out to lawyers, attorneys, judges, that this is a test that should not be used as good evidence in court anymore.
Wow. So I actually have another question relating to what you said, Liz, about the Maryland case. Was it determinative at all with their finding of overturning the conviction that it was a constitutional right in Maryland to, have abortion care? And so in another state where you don't have that right, it probably would still be able to be used as criminal intent?
That's a great,
That somebody
yeah,
would look into it?
that's a great question. So they actually just relied on the rules of evidence. Like, was it relevant? Which is, the same relevance standard in pretty much any state. So it can be used. They did reference, obviously, the right and the statutory right, but it was not determinative of the holding in that case. They also relied on the fact that, she didn't have what they considered a standard of prenatal care that they thought she should have obtained if she had wanted to not murder her baby. And they said that was also irrelevant in
Wow.
that case.
And so I guess relating to that, what level of abortion care pregnancy care does someone need to get? Like, how are they even gauging it in terms of, do they take their prenatal vitamins every day? Is that something that's used?
Right. I mean, that's part of the problem. And one of the things that the court said is like, if that's the case, it's going to be up to just the huge amount of discretion of these officers to make a determination about what is appropriate in any given situation. And just, so many people don't obtain prenatal care for a variety of reasons, so many reasons that have nothing to do with whether it's a wanted pregnancy or not, that it doesn't pass muster.
Mhm. And Christina, do these sort of laws disproportionately affect, non-citizens because they're probably not seeking this kind of care because maybe they're afraid to go to the doctor or that kind of thing?
Yeah, and also I think that's probably true, Katie, in cases. And also, there's a situation of like the US healthcare, which is like not everybody has insurance. So no matter if you want to go and seek prenatal care, you might be financially prohibited from that. And that could affect marginalized communities, communities of color, immigrant communities, low income communities. I mean, folks are obviously disproportionately affected by in many ways, but that is definitely one of them. Insurance, right?
Yeah, for sure. So relating to fetal personhood and constitutional law, how do those fetal personhood laws affect reproductive rights, and are they likely to be upheld by courts?
So just to define what fetal personhood laws are for everyone on the call, they basically recognize that a fetus and even sometimes an embryo or a fertilized egg even has equal rights as the person, the pregnant person or any person under the state's laws. And, they're really a legal fallacy that threaten the fundamental rights of pregnant people. States have relied on principles of fetal personhood to sanction surveillance of pregnant people, to force unwanted medical interventions on pregnant people, to deny pregnant people necessary medical care, and have, threatened even the ability to obtain or continue with in vitro fertilization. And again, I'm going to shout out Pregnancy Justice, which really focuses on that issue and discusses also like its historical context, that's really rooted in ideas and the history of slavery in this country, that an enslaved person's pregnancy was really a source of wealth to the enslavers, and so elevating the value of the fetus above that of the pregnant person's humanity. Oh, sorry about that, everyone. And so they have a huge impact on the dignity of pregnant people in this country. And it's a question about whether these laws are going to be upheld. And it's very likely going to depend on what court and where we're talking about. There are lots of constitutional challenges that could be made depending on how they're used and how they're implemented, including substantive due process arguments, vagueness, they lead to absurd results. And even religious freedom grounds for folks, depending on the circumstances. And so it's really hard to say what's going to happen in the future, but we are seeing, you know, more and more states adopt fetal personhood in some way or another.
I think in Texas, we sort of have the first wave of this fetal personhood idea, which happened 25 or 30 years ago. It didn't really elevate fetal personhood to the level of constitutional equal protection, which is now what the argument is, but it redefined individual in the penal code to include an unborn child. And so every crime in the penal code that you can commit against an individual, you can theoretically commit that crime against an unborn child. And that's leading to a lot of the criminalization of pregnant people that Cristina has talked about and that we've seen, is that if we really think this pregnancy is another individual, then anything you may do to cause risk or harm to your own pregnancy could be a crime in lots of different ways. So we sort of have this little piece of it already in effect in Texas.
Wow, that is crazy. So as far as cross-state legal battles, what are the legal arguments for and against states prosecuting providers or patients across state lines?
Yeah, so I talked a little bit earlier about the limits of a state's jurisdiction to prosecute conduct that occurs wholly out of state. And beyond the arguments against cross-state enforcement we've already talked about, I did want to also eventually discuss shield laws. So where we're really seeing this play out is states that have threatened to prosecute providers who are practicing in states where abortion is allowed, and somehow there's conduct that happens in the banned state. And in particular, we've seen these types of threats where there are providers who are practicing telemedicine from what's called a shield state and sending abortion medication to be taken by a patient in the banned state. And so many of you have probably seen that there was an indictment out of Louisiana charging a New York-based provider with doing just that, sending abortion medication to a patient in Louisiana. But even if the state has jurisdiction over that conduct, which is still an open question, the bigger hurdle really for prosecuting these out-of-state providers is whether that prosecuting state is able to extradite the provider from the shield state in order to proceed with that prosecution. And so the Constitution, the US Constitution, only requires extradition for fugitives. And fugitives are defined as, committing a crime in one state and fleeing in order to avoid prosecution, that state into another state. Otherwise, each governor of each state has discretion about whether to extradite someone within their state. And states have enacted, some states have enacted shield laws that further even place limits on their governor from extraditing where the reproductive care that is provided is lawful in that shield state. And some of those shield laws also include providing gender-affirming care as well. And so in the case of the Louisiana prosecution, for example, the New York governor has declined to and is refusing to extradite that New York doctor. Shield laws also make it difficult for the prosecuting state to obtain evidence that is located in the shield state, because some of these shield laws, and each state's shield laws are different, but some of the shield laws say that the state's officers or employees are forbidden from assisting with these out-of-state prosecutions. So, for example, an out-of-state subpoena couldn't be enforced or wouldn't be enforced by the shield state courts and officers if it concerned care that was lawful in the shield state. And so these are, novel questions of law that we're going to see play out and we're following very closely. But I think, definitely provide hurdles to prosecution.
And then I know we've gotten into this a little bit on other questions, but I just want to make sure we covered this fully as far as the impact on marginalized communities and how abortion bans and pregnancy prosecutions disproportionately impact those low income individuals and communities of color. Is there anything you wanted to add on that, guys?
Yeah, I think I would, Katie, you had a really good insight when you were talking about, when we were talking about prenatal care and insurance, all of that. But I think, again, just like these marginalized communities, like low income communities or communities of color, have always been heavily surveilled. Have the research has shown they are always disproportionately affected by what some people call the child welfare system, and what the language that I like to use is the family policing system. And so I think those numbers remain true, which is they are heavily surveilled. Which means also their pregnancies are heavily surveilled. And actually there's some recent litigation coming out of, was it New Hampshire or Vermont, y'all? Pregnancy Justice was bringing against, they were basically saying that folks of certain communities were being targeted for removal or termination of the parental rights. And it seemed to be a certain group that they were going after. So that's still being litigated. That's kind of newer, but again, this stuff is not new. So the same folks that were heavily surveilled as communities of color or low-income individuals, their pregnancies are, of course, highly scrutinized and surveilled. But there's also, we've noticed, or I guess we've reported on recently, because again, it's been happening, healthcare involvement. So in the same study I was talking about earlier about the 3 years post-Dobbs tracking pregnancy prosecutions, the Pregnancy Justice Report, out of those 210 cases that were discovered in the 1 year post-Dobbs, 121 of those 210 cases, information was obtained or disclosed in a medical setting, meaning that folks that did go to seek care or had some type of emergency where they ended up at some kind of clinic or hospital have been at times reported by healthcare providers. So when they were providing information to their healthcare providers pertaining to receiving care, have also been reported. But also in addition to that, they have cooperated with, and there's, we could do a whole nother panel on subpoenas and HIPAA and all of that. But information has been obtained from their healthcare providers and used against them either to initiate an investigation or as evidence in a criminal case. Out of those 210 cases of pregnancy prosecution in the first year after Dobbs, 115 of those cases indicated some type of involvement by the family policing system. We also think that's probably an undercount because that's just what we were able to obtain from like public court documents regarding the criminal case. And of course, we all know that with the child welfare and family policing, those are civil cases. And a lot of times that information is actually, you can't receive it, as a public document. But just to say, again, the continued surveillance and policing of low-income individuals and communities of color also applies to their pregnancies, their healthcare decisions, and it's definitely still happening.
So what cases should we be watching in state and federal courts that could redefine reproductive rights? And hopefully this is where we'll talk about the midwife case and other, really interesting new stuff.
I'll start with some cases I'm watching that are kind of directly affecting Texas, and maybe Liz has some ideas for some national perspective. I'm paying attention to the Fun Texas Choice versus Paxton case, which is in the Western District of Texas in Austin. It's a right to travel case. The abortion funds in Texas were threatened with prosecution from the Attorney General and various DAs that if they helped people get out of state to get care, they would be criminalized. So they sued to have the federal court say they were within their rights to help people. That there's an injunction in place in that case, and there's still some briefing going on, but maybe a permanent injunction will come out by the end of the summer. So watching that kind of right to travel case as it winds through the courts, I'm very interested in. The mifepristone case that was at the Supreme Court sort of continues in up and down between the Northern District of Texas and Amarillo and the Fifth Circuit about whether, you know, the FDA rules concerning mifepristone are appropriate and what remedies states might have, you know, to change that. That will have a huge impact on abortion access. And I guess to back up a little bit, side to side with the Fund Texas Choice versus Paxton case, there's a similar case in Alabama that the Yellowhammer Fund in Alabama filed, and the district court opinion from the Middle District of Alabama is in line with what the Western District of Texas says. Those trial courts said, yeah, there's a right to travel, and that means that the First Amendment right to association to help people travel is also intact. So I'm kind of watching those pretty closely.
Yeah, I'll just chime in and say those, we're obviously watching, we're watching the mifepristone case that's before Judge Kaczmarek, that is still ongoing. 3 states, basically the Supreme Court said, you know, the original plaintiffs lack standing, went back down. 3 states have intervened, they're now new plaintiffs, so it's starting all over again. But this time now we have a different administration because it's you know, the defendant in the case is the FDA. And so now we have a Biden administration who's there to defend. I'm sorry, not Biden administration, Trump administration, there to defend the FDA. So we'll see, you know, what kind of, if they change stances or what they say is going to be very interesting to watch. You know, in terms of the midwife who was recently charged, you know, I think the thing to remember is that the facts that are out in public are all coming from the prosecution. They're all coming from the police. They're all coming from law enforcement. And it's really important to remember to take everything that is being said publicly with a grain of salt. We don't really know much about anything in this case yet. It's way too early to say. But I do know she does have criminal defense counsel, local counsel, and they'll be fighting hard for her.
So, as far as legislation, what reproductive rights legislation is currently being proposed at the state and federal levels, and what's the likelihood of those passing?
I'll be happy to talk about what's happening at the state legislature at the moment, and that today means the very moment today. There are a bevy of bills that would further restrict access to abortion care and reproductive health care that have been filed. Today, the Senate State Affairs Committee is hearing 3 of them. One of them seeks to clarify the medical emergency exception. One of them prohibits local government from funding travel and other practical support, including childcare. If you needed time to, you know, go out of state to get an abortion, those funds would fund childcare, travel, all sorts of other things that could be helpful. So the legislature has a bill to prohibit that. And then there's another bill that's up, that's Senate Bill 2880, that really creates a private cause of action like SB 8 did for anyone who helps a person get medication abortion. It creates that cause of action for internet providers who put that information on their website. It's hard to describe how all the things it does, including saying the law can't be challenged. And if you're a lawyer who challenges the law, then you owe fees. And if you're a judge who says the law is unconstitutional, then you have to pay for the costs, which is like sort of way out of bounds of normal legal process. So it's a really frightening expansion of the worldview of how all powerful the people who have any sort of political power should be over other branches of government. I will say on the bright side, there's other bills that have been filed that are good, that would like repeal these bans. There's bills that have been filed that would make more significant clarification to the medical emergency exception, bills that have been filed that will create an exception for fatal fetal anomalies and for sexual assault. Bills that have been filed to make sure that insurance plans cover abortion care. So right now that would only be in a medical emergency, but if the laws change in the future, it could be more care. So there's a continual proposal, like lots of proposals on both sides, I'll say, continue despite the fact that the law is headed in one direction at the moment. And I can't, there's so much happening at the federal level, I couldn't start to try to say what Congress is actually doing on this.
Is there any like out of Texas that are interesting legislation that's going on that's pretty recent that you'd like to talk about, Liz? I know that you can't cover the full scope of other states, but just if there's anything in particular going on.
I think one thing that's interesting to have watched, so in Kentucky, recently the legislature passed amendments to its abortion ban, and they said it was to clarify the medical exceptions to make them more clear. However, the medical community said this would actually be more hurtful and make them less clear, and the governor vetoed those. Just I think yesterday or the day before, the governor vetoed, and we'll see if the legislature is going to override. So it's just like kind of interesting to see these dynamics play out, and even bills that are passed or the legislators say that they might expand care. It's really, really important to look and see what they actually say and what doctors and providers are saying they actually do. Because that might not be the case.
And I think that segues nicely to one of the questions that was put in the Q&A about the exceptions bill in Texas. In an attempt to make the law consistent across the kind of several different abortion bans, which are the current felony ban, Senate Bill 8, the pre-Roe law, the bill for the first time attempts to amend the pre-Roe law. That law does not have an exception to the prosecution of a pregnant person, and has another crime embedded in it of attempting to procure an abortion, which has been argued would make it a specific crime to help people get out of state care. And right now, some of the injunction in the Western District is based on the idea that those laws have been repealed by implication. And so obviously if the legislature amends that law, then there's no implied repeal because it's conforming the law to the modern law. So it's trying to do some good things, and people have been working hard on getting the legislature to act on this exception, but it also has some really bad unintended consequences. And I think there's people working hard to fix those consequences and keep the good things in the bill that it can do. I think I think there's a question in the chat about really where does the current law leave pregnant people? And this is a difficult question because there's maybe no good choices or difficult options. Like it's still legal today to travel out of state if you don't want to keep your pregnancy. You still can't be prosecuted for accessing telehealth. You can, if what the correct decision for you is carrying your pregnancy to term and giving it up for adoption, that's also an option. But certainly the each of those choices is more fraught than it was 4 years ago, and it's not a good healthcare situation. It's not a good public health situation that we're in. So I appreciate those concerns in the question there.
I see there's a question about in what ways are abusive ex-partners or ex-spouses empowered to report women for seeking or receiving abortion care? And I'll the first most common way that cases are tipped off to law enforcement is healthcare, if someone in the healthcare provider space, and the second is an ex-partner or a partner. And so, you know, those are, we've seen frequently DV situations that are tangled up in cases that are reported to law enforcement. And we've seen, you know, ex-partners be the source of a tip to law enforcement in these cases. And so they definitely play a role here in, you know, criminalizing care.
Yeah, and I think the question was about how those folks might be empowered to do that. I mean, the Attorney General has not been quiet about asking people to call his tip line with information. And even though the pregnant person can't be prosecuted, right, it's an attempt to prosecute anyone around them who might help. And then there's, you know, private lawyers and other movement actors who are also trying to recruit people to sue their partners who have abortion care. So there has been a certain empowerment that for those folks because of the abortion bans.
There's a question I'll read for, it says, for providers in other states that might face being extradited, even if their state won't participate in the extradition, are they at risk of another third state extraditing them if they travel to that other third state?